Defenses and discharge of the mortgage from real property. This is the Barbri outline, page 140. 1. Defenses to underlying obligation. Because the mortgage is granted to secure an obligation, if the obligation is unenforceable, so is the mortgage. Therefore, defenses in an action on the underlying obligation are defenses against an action on the mortgage, including Romanet 1, failure of consideration, Romanet 2, duress, and Romanet 3, mistake, and lastly, 4th, fraud. Consumer protection defenses to foreclosure. 2. The Dodd-Frank Wall Street Reform and Consumer Protection Act, Dodd-Frank Act, requires residential mortgage lenders to determine a mortgagor's ability to repay before extending a loan. The terms of the loan must be understandable and not unfair, deceptive, or abusive. The Act also prohibits a lender from steering mortgagors to transactions not in their interest in an effort to increase the lender's compensation. The mortgagor can assert violations of the ability to repay or anti-steering provisions as a defense in a foreclosure proceeding and be exonerated. 3rd, discharge of the mortgage. A mortgagee's right to foreclose is precluded by anything amounting to a discharge of the mortgage, such as payment of the debt secured, merger of the legal and equitable interests, or the acceptance of the mortgagee of a deed in lieu of foreclosure tendered by the mortgagor. Payment. Generally, full payment of the note discharges the mortgage lien. The agreement in the note, however, will normally govern whether the mortgagor may prepay the obligation. If the note or mortgage does not provide for prepayment, the mortgagor has no right to prepayment. The mortgage must also provide for a prepayment fee or total prohibition of prepayment for a part or all of the mortgage term. Note: the Dodd-Frank Act prohibits prepayment penalties on certain loans. Adjustable rate interest only. Merger. A mortgage lien vests the mortgagee with either an equitable interest under the lien theory or a legal interest under the title theory, while the mortgagor retains the other interest. If the mortgagee subsequently acquires the mortgagor's interest, the mortgage is said to merge with the title, and the mortgagor's personal liability on the underlying debt is discharged up to the value of the land. Deed in lieu of foreclosure, which is the last of the defenses and discharge of the mortgage section. The mortgagor may also tender the mortgage a deed in lieu of foreclosure. In effect, the mortgagor simply turns over her equity of redemption to the mortgagee. Acceptance of a deed in lieu of foreclosure permits the mortgagee to take immediate possession without the formalities of foreclosure sale. Although it is common to negotiate a complete release from the debt, the parties also have the option to negotiate a mortgagor's agreement to remain liable on some portion of the debt. Mortgagors cannot be compelled to tender such a deed, and mortgagees have the right to refuse the deed and proceed to foreclosure. Possession before foreclosure. This is letter D, subpart D. When a mortgagor defaults on his debt, the mortgagee can sue on the debt or foreclose on the mortgage. A mortgagee may wish to take possession of the property or begin receiving the rents from the property before foreclosure. This is especially important in states where foreclosure is a lengthy process. 1. Theories of title. The mortgagee may have a right to take possession before foreclosure, depending on the theory the state follows. A lien theory. According to the lien theory, the mortgagee is considered the holder of a security interest only, and the mortgagor is deemed the owner of the land until foreclosure. A majority of the states follow this theory, which provides that the mortgagee may not have possession before the foreclosure. Title theory. Under the title theory, legal title is in the mortgage until the mortgage has been satisfied or foreclosed. A minority of states follow this theory, which provides that the mortgagee is entitled to possession upon demand at any time. In possession, this means that as soon as a default occurs, the mortgagee can take possession. The intermediate theory. The intermediate theory is a compromise position in which legal title is in the mortgagor until default, and upon default, legal title is in the mortgagee. Only a handful of states follow this theory, which provides that the mortgagee may demand possession when a default occurs. There is little practical difference between this theory and the title theory, which I'll read one more time. Under the title theory, the legal title is in the mortgagee until the mortgage has been satisfied. Whereas the lien theory, the mortgagee is considered the holder of a security interest only, and the mortgagor is deemed the owner of the land until foreclosure. Two, under the possession before disclosure section, all states agree. This is mortgagor, consent, and abandonment. All states agree that the mortgagee may take possession if the mortgagor gives consent to do so, or if the mortgagor abandons the property. And third, risks of mortgagee in possession. The mortgagee who takes possession prior to foreclosure can intercept the rents, prevent waste, make repairs, and lease out vacant space. However, despite these advantages, most mortgagees do not wish to take possession because of the liability risks it presents. The risks include a very strict duty to account for all rents received, a duty to manage the property in a careful and prudent manner, and potential liability and tort to anyone injured on the property. Receiverships. Instead of becoming a mortgagee in possession, most mortgagees attempt to intercept the rents before foreclosure by getting a receiver appointed by the court to manage the property. Courts will generally appoint receivers for rental property upon showing of some combination of three factors. 1, that waste is occurring. 2, that the value of the property is inadequate to secure the debt. And 3, that the mortgagor is insolvent. Subpart E, foreclosure. Foreclosure is a process by which the mortgagor's interest in the property is terminated. The property is generally sold to satisfy the debt in whole or in part. Foreclosure by sale. Almost all states require foreclosure by sale. All states allow judicial sale, while about one-half also allow non-judicial sale under power of sale. The non-judicial sale is often permitted with deeds of trust, but not with mortgages. Foreclosure sales are conducted by auction, which the highest bidder taking the property. With the highest bidder taking the property. The lender may bid at the sale, and in many cases, the lender is the sole bidder. Note, for convenience, the discussion below speaks of mortgagors and mortgagees, but the same principles apply to deed and trust trustors and beneficiaries. Redemption and equity. At any time prior to the foreclosure sale, the mortgagor has the right to redeem the land or free it of the mortgage by paying off the amount due, together with any accrued interest. If the mortgagor has defaulted on the mortgage or note that contains an acceleration clause permitting the mortgagee to declare the full balance due in the event of default, the full balance must be paid in order to redeem. The mortgagor's right to redeem her own mortgage cannot be waived in the mortgage itself. This is known as clogging the equity of redemption and is prohibited. However, the right can be waived later for consideration. Statutory redemption. About half the states give the mortgagor, and sometimes junior lienors, a statutory right to redeem for some fixed period after the foreclosure sale has occurred. This period is usually 6 months or 1 year. The amount to be paid is usually the foreclosure sale price rather than the amount of the original debt. Be careful to distinguish equitable redemption, which is universally recognized but only up to the date of the sale, from statutory redemption, which is only recognized by about half the states and applies only after foreclosure has occurred. Priorities. Generally, a priority of mortgage is determined by the time it was placed on the property. When a mortgage is foreclosed, The buyer at the sale will take title as it existed when the mortgage was placed on the property. Thus, foreclosure will terminate interest junior to the mortgage being foreclosed, but will not affect senior interests. A. Effect of foreclosure on various interests. Junior interests destroyed by foreclosure. Foreclosure destroys all interests junior to the mortgage being foreclosed. In other words, junior mortgages, liens, leases, easements, and all other types of interests will be wiped out. If a lien senior to that of the mortgagee is in default, the junior mortgage has the right to pay it off, redeem it, in order to avoid being wiped out by its foreclosure. Thus, those with interests subordinate to those of the foreclosing party are necessary parties to the foreclosure action. Failure to include a necessary party results in the preservation of that party's interest despite foreclosure and sale. So this is why foreclosures have to be announced, and all of the parties need to join in the foreclosure action, because there's ways around this. Senior interest not affected. Foreclosure does not affect any interest senior to the mortgage being foreclosed. The buyer at the sale takes subject to such interest. She does not become personally liable on such senior interest, but she will be forced to pay them in order to prevent their foreclosure in the future. B. Modification of priority. As noted above, priorities among mortgages on the same real estate are normally determined simply by chronology. The earliest mortgage paid on the property is first in priority. The next mortgage is second, and so on. However, the chronological priority may be changed in the following ways. 1. Failure to record. 2. Subordination agreement. And 3. Purchase money mortgages. So, if the first mortgage fails to record and the second mortgage records, gives value, and takes without notice of the first, the second mortgagee will have priority over the first by virtue of normal operation of the recording acts. Subordination agreement. A first mortgagee may enter into an agreement with a junior mortgagee, subordinating its priority to the junior mortgagee. Such agreements are generally enforced. However, a broad promise to subordinate to any mortgage or a vaguely described mortgage to be placed on the property in the future may be considered too inequitable to enforce. 3. Purchase money mortgages. A purchase money mortgage is a mortgage given to a vendor of the property as part of the purchase price, or a third-party lender who is lending the funds to allow the buyer to purchase the property. A PMM, whether recorded or not, has priority over mortgages, liens, and other claims against the mortgagor that arise prior to the mortgagor's acquisition of title. However, PMM priority is subject to being defeated by subsequent mortgages or liens by operation of the recording acts, or may be altered through a subordination agreement. And this is part of Restatement Third of Property Mortgages, Section 7.2, and demonstrated in Slaughter v. United States. Example: A properly records a judgment lien against O, which will attach to any after-acquired property of O. O finances the purchase of Blackacre with a $250,000 loan from B. B does not record its mortgage. A few months later, O borrows $10,000 from C in exchange for a mortgage on Blackacre. C records her mortgage. B's purchase money mortgage has priority over A's lien because the lien arose before O acquired title to Blackacre. For example, the general priority rule governing PMMs. But it is junior to C's mortgage under any recording act because C had no notice of B's interest and recorded first. Vendor PMM versus third party PMM. As between two purchase money mortgages, one to the vendor and one to a third-party lender, the vendor's mortgage is usually given priority over the third-party lender's. Because both PMMs arise from the same transaction, neither is treated as subsequent under the restatement. Thus, the recording acts do not apply unless only one party has notice of the other. However, some jurisdictions that do not follow the restatement allow the recording acts to determine priority between all PMMs. B. Third-party PMM versus third-party PMM. If two purchase money mortgages are given to two third-party lenders, their priority is determined by the chronological order in which the mortgages were placed on the property, the recording act, and a subordination agreement, if any. Note that in these cases, the recording acts are often of no use because two purchase money mortgages will almost always know of each other's existence and thus have notice. Modification of senior mortgage. Suppose there are two mortgages on the land. The landowner enters into a modification agreement with the senior mortgagee, raising its interest rate or otherwise making it more burdensome. The junior mortgage will be given priority over the modification. For example, if the first mortgage debt is larger because of the modification, the second mortgage gains priority over the increase in the debt. Optional future advances. In general, this is fifth, in general, a mortgage may obligate the lender to make further advances of funds after the mortgage is executed, and such advances will have the same priority as the original mortgage. However, if a junior mortgage is placed on the property and the senior lender later makes an optional advance while having notice of the junior lien, the advance will lose priority to the junior lien. An optional advance is one that the lender is not contractually bound to make. Numerous states have reversed this rule by statute, but it remains the majority view. I think this advance would be in the case of a construction mortgage. And some inspection is done before they advance monies to proceed with the next stage. Subrogation. 6. A mortgage taken out for the purpose of refinancing a pre-existing senior mortgage takes the priority position of the senior mortgage. Bank A holds a $100,000 senior mortgage on a tract of land owned by O. Bank B holds a $50,000 second mortgage on the same land. Bank C owns O Bank C loans O $100,000 secured by a new mortgage, which O immediately uses to pay off Bank A's mortgage. Bank C now has the senior mortgage, and Bank B still has the junior mortgage. Note that Bank B has not been harmed. Bank C's mortgage simply replaced Bank A's. C. Proceeds of sale. The proceeds of the foreclosure sale are used first to pay expenses of the sale. Attorney's fees and court costs. Then to pay the principal and accrued interest on the loan that was foreclosed. Next to pay off any junior liens or other junior interests in order of their priority. And finally, any remaining proceeds are distributed to the mortgagor. In many cases, there is no surplus remaining after the principal debt is paid off. So I feel like this conflicts with what I read earlier, talking about the effect of foreclosure on various interests when junior interests were destroyed by the foreclosure and senior interests were not affected. So I guess this is assuming that the junior liens had enjoined in the foreclosure action, like I said, but it's not specifically called out here. Deficiency judgments. If the proceeds of the sale are insufficient to satisfy the mortgage debt, the mortgagee can bring a personal action against the mortgagor debtor for the deficiency. However, a number of states limit the deficiency that can be recovered to the difference between the debt and the property's fair market value when the fair market value is higher than the foreclosure price. Other states prohibit deficiency judgments entirely on PMMs and on deeds of trust that are foreclosed by power of sale. Assume that land has a fair market value of $50,000 and is subject to 3 mortgages executed by its owner whose name is MR. The mortgages have priorities and secure outstanding debts in the amounts shown in the depiction, to ME1 for $30,000, to ME2 for $15,000, and to ME3 for $10,000. In that order. Assume that mortgage 1 is foreclosed and the bid of the sale is $50,000, the fair value of the land. How will the funds be distributed? In an actual case, the funds would first be used to pay any attorney's fees and expenses of the foreclosure and then to any accrued interest on mortgage 1. However, we will assume that these items are zero. The $50,000 in funds from the sale will then be used to pay off the mortgages in order of their priority. Thus, $30,000 is applied to fully pay off ME1, then $15,000 for ME2, and the remaining $5,000 for ME3, which is applied right. Because this is not enough to discharge mortgage 3 fully, mortgage 3 is left with a deficiency of $50,000 and may sue MR, the mortgagor, for a personal judgment in this amount unless anti-deficiency statutes prohibit it. Assume the same facts as above, except that the bid at the sale is $60,000 rather than $50,000. This will allow the full payment and leave a surplus of $5,000. Assuming there are no further liens or encumbrances on the property, this $5,000 will be paid over to the mortgagor. Now assume the same facts as in the original problem, except that it is mortgage 2 that is being foreclosed. Mortgage 1 exists, but it is either not in default or its holder has not yet taken action to foreclose it. Recall from the outline that the foreclosure does not affect any interest senior to the mortgage being foreclosed. Thus, foreclosure of mortgage 2 will not affect mortgage 1, which will continue to exist on the property in the hands of the foreclosure sale purchaser. Such a purchaser will not be personally liable to pay mortgage 1 off, but as a practical matter, if mortgage 1 is not paid, sooner or later ME will foreclose it. Hence, the buyer at the mortgage sale of mortgage 2 will have strong economic incentive to pay mortgage 1. Otherwise, she will be subjected to a foreclosure action of the mortgagee 1 and may will lose much or all of her investment in the property. What will a wise bidder at the foreclosure sale on mortgage 2 bid? The maximum is $20,000, which is the fair value of the land, $50,000 minus the amount the successful bidder will subsequently have to pay to discharge the mortgage, $30,000. If the bid at the foreclosure sale of mortgage 2 is $20,000, how will the money be distributed? None of it will go to mortgagee 1 because he still has his mortgage on the property. $15,000 of the funds will be applied to fully pay off mortgage 2, and $5,000 will remain to be applied against the $10,000 balance owed on mortgagee 3, which is, of course, wiped out by the foreclosure of mortgage 2. Mortgagee 3 will still have a $5,000 deficiency, as in the first example above. Installment land contract. So you pay nothing, and you don't take the property. Installment land contracts. Installment contracts may provide for forfeiture rather than foreclosure as the vendor's remedy in the event of default. However, because forfeiture is often a harsh remedy, the courts have tended to resist enforcing forfeiture clauses, and in doing so have developed the following theories: equity of redemption 1, restitution 2, treat as a mortgage 3, waiver, and 5th, election of remedies. In 1, equity of redemption, several states allow the contract purchaser who is in default to pay off the accelerated full balance of the contract and to keep the land. In other words, they grant the purchaser a grace period. This is roughly analogous to the equity of redemption in mortgage law. A few states have statutory schedules of grace periods, which often provide for a longer time if a greater percentage of the total price has been paid. Restitution, number 2. A number of decisions allow actions by the vendor for forfeiture on the land, but require her to refund to the purchaser any amount by which his payments exceed the vendor's damages. The court may measure these damages by the property's fair rental value while the purchaser was in possession, or by any drop in market value since the contract was executed. 3rd, treat as mortgage. A few states, by statute or case law, now treat installment contracts like mortgages, at least for purposes of the vendor's remedies. In effect, the vendor must foreclose the contract by judicial sale in order to realize on the real estate, and she cannot simply reclaim the land. Waiver. 4. Many cases hold that where a vendor has established a pattern of accepting late payments from the purchaser, she cannot suddenly insist on strict on-time payment and declare a forfeiture, and such payment is not forthcoming. Such a pattern is said to constitute a waiver of strict performance. To reinstate strict performance, the vendor must send the purchaser a notice of her intention to do so and must allow reasonable time for the purchaser to make up any late payments and to get back on stream. 5. Election of remedies. It is commonly held that the vendor who elects to pursue a forfeiture cannot also bring an action for damages or for specific performance. The vendor must choose only one remedy and forego all others.